we house the government units with regard to taxation, local taxation, fees, and charges. I will be discussing a short intro into the subject with uh, further elaboration to be done by my group mates. So let's talk about the local government taxation as prescribed in the local government code. So, local government taxation, Book 2, Title 1, Chapter 1, General Provisions. So, Section 128, Scope. The provisions herein shall govern the exercise by provinces, cities, municipalities, and barangays of their taxing and other revenue-raising powers. So, Section 129, Power to create sources of revenue. Each local government unit shall exercise its power to create its own sources of revenue and levy taxes, fees, and charges subject to the provisions herein, consistent with the basic policy of local autonomy. Since we have a policy of local autonomy in the 1987 Constitution, where local government units are further given powers through the provisions of the 1987 Constitution on local autonomy and further encapsulated in the local government code. So, local government units are given the power to raise their own sources of revenue and levy taxes, fees, and charges, which such collection of the taxes, fees, and charges shall accrue or be given exclusively to the local government units. Uh, so what is the constitutional basis for such a power? So the constitutional basis for the power of the LGU to tax is prescribed in Article 10, Section 5 of the 1987 Constitution, which provides that the Section 5 that each local government unit uh, shall have the power to create its own sources of revenues and to levy taxes, fees, and charges subject to such guidelines and limitations as the Congress may provide, consistent with, again, the basic policy of local autonomy. Such taxes, fees, and charges shall accrue exclusively to the local governments. So we now know that the uh, LGU has the power to levy taxes to create or raise their own sources of revenue. So naturally, since this is a power to tax, we now ask the question where did this come from? So obviously this comes from the Constitution, but is it inherent? Since we all know that the power to tax is reserved in Congress as the uh, power of the purse, the governmental body, which has the power to levy taxes. So since the power of Congress cannot be delegated, we ask the question now whether it is inherent the power of local government units to levy taxes. So, so is the power of the local government unit to tax an inherent power? So in this case example we have here, Reyes versus Cornista, the answer is no. The power to levy taxes is not inherent in municipal corporations. This applies equally well to license and occupation taxes. The fact that the state creates municipal governments does not by implication clothe them with the power to levy taxes. Because as we know before, there were numerous iterations of laws that we could consider to be earlier versions of local government code. But here, uh, so the fact that local governments are created does not mean that they have the inherent power to tax. So that power must be conferred in clear terms or must result by a necessary implication from the language made use of in law. So what language is that? So we find it in Article 10, Section 5 of the 1987 Constitution and the previous here, the previous sections found in the local government code. So taxation then is a sovereign state governmental power. So it's a sovereign state. So we when we say sovereign state, it's of course a country, a state. Since local government units are not a state, they don't have the inherent power to levy taxes unless it is delegated to them. So how is this delegated? Uh, since the power of Congress cannot be delegated further, what is delegated cannot be delegated further. So where do we have the answer in that? It is through express constitutional grant, i.e. Article 10, Section 5 of the 1987 Constitution. And it is further found in the local government code. The and must look to the statutory grant for such an authority as they possess in the imposition of taxes. So there is the constitutional provision, and then further provisions you can find in Book 2, Title 1, Chapter 1, the local government taxation, the further outlining the fundamental principles, the limitations of the LGU's power, and the limitations of the LGU's power to tax. So since local government units were given the power to tax, who what who then or what instrumentality of the government unit has the authority to levy taxes? We can find it in Section 132. Uh, as we know, since Congress has the power to raise taxes, then we find by a this version in the local government exemplified by the Sangguniang Bayan. So Section 132 of the local government code provides that local taxation authority the power to impose a tax, fee, or charge or to generate revenue under this code shall be exercised by the sanggunian of the local government unit concerned through an appropriate ordinance, which the process will later be expounded on and explained by my group mates. So here we have a Section 130, the fundamental principles. Although I just put this here so that we can have a brief overview of its fundamental principles, which is, as we know, it shall be uniform in each local government unit. Taxes, fees, and charges and other impositions shall be equitable and based as far as practicable on the taxpayer's ability to pay. Be levied and collected only for public purposes, public purpose only, not be unjust, excessive, oppressive, or confiscatory, and not be contrary to law, public policy, national economy policy, or in the restraint of trade. It shall be in no case be let to any private person. So the collection is the responsibility and duty of the government, not of a private person. So the revenue collected shall be used ensure solely for the benefit of and be subjected to the disposition of the local government unit levying the tax, fee, charge, or other imposition unless otherwise specifically provided herein. And each local government unit shall, as far as practicable, evolve a progressive system of taxation. So since LGUs are given the power to levy taxes, does it have limitations? Is it absolute? Of course, LGU's taxing powers are not absolute. There are numerous limitations, which will be expanded later on by my group mates, which can be found in the Constitution, the local government code, uh, and other sources of limitations. So here we have non-delegability. The power to tax cannot be delegated to private entities since it is a delegated power to the by express constitutional grant, it cannot be delegated further. And uniformity and equality, taxes must be uniform and equitable within the religious jurisdiction. So it must be used for a public purpose only, not for any other purpose. So constitutional statutory provisions, of course, LGUs are prohibited from levying certain taxes, such as those explicitly reserved for the national government. One thing we also know is that you cannot tax the government subject to certain exceptions. So income tax, customs duties. So to recap, where does it derive its power? By express constitutional grant. Here we have the exception on delegability, negated by the Constitution, express constitutional grant, further simplified in the local government code, power to levy taxes exclusively for the local government units. Not inherent, the power is not inherent. This by express constitutional grant, since we cannot have a state within a state, so the local government unit is not a sovereign state. And who has the authority to levy those taxes? We have the local taxation authority. And fundamental principles, limitations. So with that, I give the further discussion to my group mates. Thank you.
Good day, everyone. Today we'll explore the taxing powers of local government units in the Philippines. You might wonder, why should we care about taxation? Well, taxes are literally the lifeblood of government. Without taxes, there would be no roads to drive on, no public schools for children, no health centers for the sick, and no police and fire protection. When we talk about taxing powers, we're really talking about legal authority of our provinces, cities, municipalities, and barangay to collect money from their constituents to fund public service. Think of it this way. The national government collects income tax from your salaries, but your cities collects business permit fees. Your municipalities collect real property tax on your lands, and your barangay collects clearance fees. Each level of government has specific powers, and that's what we'll break down today. Constitutional basis. Let's start with the foundation. Everything starts with the 1987 Philippine Constitution, our fundamental law of the land. Article 10, Section 5 is crucial because it explicitly states that each local government unit shall have the power to create its own sources of revenues and to levy taxes, fees, and charges. Why is this important? Because this constitutional guarantee local governments were heavily dependent on the national government for money, what we call the dolly out system. But the Constitution changed that by embracing the principle of local autonomy. This means the local government units should be self-reliant and have fiscal independence. Imagine if your province had to ask Manila or the national government for permission every time it wanted to build a new hospital or fix a bridge. That would be inefficient. So the Constitution empowered local governments to raise their own revenues through taxation. This is why so your city can impose business taxes, your provinces can collect transfer fees, and so on. It's constitutionally guaranteed, meaning it can be easily taken away by ordinary laws. So we have to, I have also to emphasize that this constitutional basis means that this power is fundamental and protected. It is not a privilege, but it's rather a right of the local government units. Now, while the Constitution gives the general power, the specific details comes from a law called the Republic Act 7160, or also known as the Local Government Code of 1991. Think of the Constitution as a blueprint of the Local Government Code, and the Local Government Code as the detailed construction manual. Book 2 of the Local Government Code, specifically Section 129 until 196, is like an encyclopedia of local taxation. It tells us exactly what taxes each local government unit can collect, how much they can charge, and what the procedures are, and what the limitations are. For example, the Constitution says that local government can tax, but it doesn't say how much or what kind of taxes. That's where the local government code comes in. It says cities can impose business tax up to 2%, provinces can charge transfer tax to 50% to 75%, and so on. Without this law, the constitutional provisions would be too vague to implement. Next, the local government was enacted in 1991 as part of the decentralization movement. This means that the transferring power from the national government to local government units. This was a historical shift in the Philippine governance. So before we dive into the specific taxes, we need to understand the rules of the taxing power, the principles that govern all local taxation. These principles protects both the government's right to tax and the people's right to fair treatment. First, is the uniformity. This means if you own a restaurant in Quezon City and I also own a restaurant in Quezon City, we should both pay the same tax rate. The local government cannot play favorites or discriminate businesses. However, uniformity only applies within each local government. Quezon City can have a different rate from Makati City. Second general principle is equity and ability to pay. Taxation should be fair. A millionaire should pay more than a maximum wage earner. A large shopping mall should pay more than a small sari-sari store. This is why business taxes are often based on gross sales, and bigger businesses naturally pay more. Third is efficiency in collection. Tax collection shouldn't be bureaucratic or harassing. You shouldn't have to go through 10 offices and wait 6 months to pay your taxes. The process should be straightforward. Fourth and last is no oppressive taxation. Taxes can be heavy, yes, but they should never be so excessive that they destroy businesses or impoverish citizens. If a tax takes 90% of your income, that would be confiscatory or unconstitutional. The local government code sets maximum rates to prevent this abuse. Now, since we understand the foundation and principles, let's get specific. We'll examine each type of local government unit, starting from the largest, the province. Provincial taxing powers are detailed specifically in Section 134 of the Local Government Code. Provinces have 6 major types of taxes. To explain each with practical examples. So, first is the transfer tax, which takes up to 50% to 75%. When you sell land or a house, the province charges this tax. If you sell property worth 1 million, the province collects 5,000 to 7,500. This is separate from the national capital gains tax. Second is the tax on business of printing and publication. This applies to printing presses and publishers operating in the province. It is based on their gross receipts. Third is the franchise tax, which takes up to 50% of 1%. If a business operates under a franchise, like a bus company with a franchise to operate the province, they pay this tax. Maximum is 5% of gross receipt. So a bus company earning 100 million annually pays up to 500,000 or half a million to the province. Fourth is a tax on sand, gravel, and quarry resources. When companies extract sand, gravel, or stones from provincial lands, they pay this tax. It is based on volume or value extracted. This is important because provinces have natural resources that should benefit the local communities. Lastly is the provincial tax. um, Doctors, lawyers, engineers, accountants, all licensed professionals work in the province, pay their annual fee. It's minimum, it's minimal, just a 300 pesos maximum. But when you have thousands of professionals, it adds up. And also, it was not indicated in the um, slide. The major the sixth tax type is amusement tax, which got up to 30%, such as movie theaters, concert venues, cockpits, amusement parks, and entertainment establishment pays this tax. If a concert sells 1 million worth of tickets, the province can collect up to 300,000 pesos. Uh, we should also emphasize that uh, these diverse revenue sources, provinces don't rely on just one tax, but multiple schemes. This is fiscal sustainability. Now let's move to the cities. Cities have the broadest and most extensive taxing powers among all local government units. This is outlined in Section 143 of the Local Government Code. Why do cities have more power? This is because cities are typically more urbanized, economically developed, and have greater financial needs. These, so let's break down the first set of the city taxes. So we have community tax. This is the old cedula or resident certificate. Every resident and business pays a minimal annual community tax, usually I don't know, mga around 5 to 50 for individuals. It's small but symbolically important. Next is business tax, up to 2% of the gross sales receipt. This is the big one, the major revenue source of cities. Every business operating in the city pays this tax quarterly. So this is why business tax is crucial. It's recurring and substantial. Next is tax on banks and financial institutions. Here's something special. Only, again, I repeat, only cities and provinces can tax banks, not municipalities. This recognizes that banks are high revenue businesses, typically located in more urbanized areas. Cities charge banks a percentage of their gross receipt. Next is the franchise tax, which got up to 50% of the 1%, same as provinces. Businesses with franchises pays this. Um, Also same with the tax on quarry resources, same as the provinces. Next is the professional tax, which is same with the provinces. Cities collects this form of licensed professionals as well. Okay. Next is the amusement tax. Same with the province. Entertainment venues pays this. Then we have annual fixed tax on delivery trucks or vans. Cities can charge businesses that uses delivery vehicles a fixed annual fee. This helps maintain roads that that these vehicles usually use. Tax on petroleum products. When gasoline stations sells fuels, cities can collect up to at least 10 centavos per liter. This might seem small, but imagine millions of liters sold daily. It adds up quickly. Real property tax. This is also uh, major in in terms of the city tax. All lands, buildings, and improvements within the city are taxed annually. If your property is assessed to 1 million, you pay up to 20,000 annually. For commercial properties worth hundreds of millions, this tax is substantial. Next is the special levy on idle lands. To discourage land speculations and encourage productive use, cities can impose additional charges on lands that remain vacant and unused. Lastly, is the community tax. Already mentioned earlier, but worth repeating, it's universally collected community tax. So, for the taxing power of cities, real property tax is the most stable revenue source. It's predictable and recurring, unlike business tax that fluctuates with economic condition. Property tax is steady. Next is the municipalities. The Section 142 governs their taxing powers. Municipalities are similar to cities, but with one critical difference. Municipalities have almost the same taxing powers as cities with one major exception. They cannot tax banks and other financial institutions. Why? Because the law recognizes that banks and major financial institutions typically locate in cities, but municipality in typically locates in cities, not in municipalities, because cities have larger markets and better infrastructure, giving cities the exclusive power to tax banks, prevents revenue competition, and ensures cities can fund their more extensive urban services. But don't estimate the municipalities. They have also a powerful revenue tools such as the business tax, professional tax, real property tax, and community tax, which is a universal collection. Plus, all other taxes cities can impose except the bank tax. For agricultural or less urbanized areas, these taxes are still sustainable, are substantial. However, municipalities rely heavily on real property tax since they may have less commercial activities than the cities. Finally, uh, we have the barangay taxing powers, the smallest and most basic political unit. There are um around, according to my research, around 42,046 barangays in the Philippines. And Section 152 of the Local Government Code covers the revenue powers. So barangay are unique because they have very limited direct taxing powers. Unlike provinces, cities, and municipalities, they have imposed various taxes. However, barangays primarily collect service fees and charges. Why? Because barangays are designed to be the most accessible government unit focus on basic community services like maintaining peace and order, resolving disputes, and issuing clearances. They are not equipped with taxing enforcement machineries. So what can the barangays collect? So we have enumerated barangay clearance fees, which is a maximum of 100. This is the most common before you get a job or apply for a business permit. These fees are collected. Other service fees, such as fees for renting the barangay facilities like sports complex or other barangay services. Where do barangays get most of their money? Actually, barangays depend heavily on two sources. The IRA, or the Internal Revenue Allotment, which means that the national government shares a portion of the national taxes with all local government units, including barangays. Barangays receive a substantial portion of their budget from the Internal Revenue Allotment given by the national government. And second source is their share of the city and municipality tax. So when cities and municipalities collect taxes, they must have a portion with the barangay within their jurisdiction. So let's highlight one tax that unites provinces, cities, and municipalities, the real property tax, or the RPT. This is arguably the most important local tax. Why? Because first, it is stable and predictable. Land doesn't disappear, buildings remain, unlike businesses that can close or move. Property stays put. This makes RPT a reliable revenue source year after year. The limitations on taxing powers will be discussed comprehensively with the next reporter. Tax ordinances requirements. And that's it.
Good day, everyone. Good day, Father Dan. Good day to my fellow classmates. And we are now proceeding to the limits of taxing powers. First, we will talk about Section 130, which provides the fundamental principles. The following fundamental principles should govern the exercise of the taxing and other revenue-raising powers of the local government units. So first, A, taxation shall be uniform in each local government unit. This means that a tax must apply the same rate and under the same conditions to all taxpayers within the same class inside the same local government unit. It does not require identical rates across different local government units. Classifications must be reasonable and related to the purpose of the tax. Letter B, taxes, fees, charges, and other impositions shall, number one, be equitable and based as far as practicable on the taxpayer's ability to pay. This means that rates and bases should reflect taxpayers' relative capacity. Higher capacity may bear higher rates or broader bases. Low capacity sectors may receive lower rates, thresholds, or exemptions if reasonably justified. Number two, be levied and collected only for public purposes. This means that impositions must primarily fund legitimate local public purposes, for example, basic services and infrastructure. Incidental private benefit does not void tax if the dominant aim is public. Number three, not be unjust, excessive, oppressive, or confiscatory. This means that amounts and methods must be reasonable. A levy that effectively destroys a local business, penalizes beyond regulation, or takes property without fair relation to the service regulation is invalid. Number four, not be contrary to law, public policy, national economic policy, or in restraint of trade. This means that local taxes must conform to national law and policy, and must not unduly hinder lawful trade, competition, or inter-local government unit commerce. Next, we proceed to letter C. The collection of local taxes, fees, charges, and other impositions shall in no case be led to any private person. This just means that LGUs may not farm out or delegate the collection of local taxes or fees to private persons. Collection is a governmental function that must remain with public officers, subject to auditing and accountability. Letter D. The revenue collected pursuant to the provisions of this code shall inure solely to the benefit of and be subject to disposition by the local government unit levying the tax, fee, charge, or other imposition unless otherwise specifically provided herein. So D means revenues belong to and are disposed by the local government unit that imposed them, except where the code itself specifically provides otherwise. For example, mandated shares with barangays community tax apportionment. Letter E. Each local government unit shall, as far as practicable, evolve a progressive system of taxation. This just means that local government units shall design tax structures where the effective burden increases with the taxpayer's ability to pay to the extent local conditions and administrative feasibility allow. Now we proceed to section 133, common limitations on the taxing powers of local government units. So, section 133 provides common limitations of taxing powers of local government units. Unless otherwise provided herein, the exercise of the taxing powers of provinces, cities, municipalities, and barangays shall not extend to the levy of the following. So these are the limitations for taxing powers of local government units. So letter A, income tax except when levied on banks and other financial institutions. This shows that LGUs cannot impose income taxes. The lone carved out is the local business tax on banks and other financial institutions under section 143 F, which is measured by gross receipts, not net income. So letter B, documentary stamp tax. DST is a national tax under the NIRC, which use cannot levy it. Letter C, taxes on estates, inheritances, gifts, legacies, and other acquisitions, modus causa, except as otherwise provided herein. So C means estate. LGUs cannot impose estate of donors taxes. This does not require the provincial transfer tax on real property under Section 135, which is distinct from estate or donors taxes. Letter D, customs, duties, registration fees of vessels, and wharfage on wharves, tonnage, dues, and all other kinds of customs fees, charges, and dues except wharfage or wharves constructed and maintained by the local government unit concerned. So D, all customs exactions are national. LGUs may charge wharfage only on wharves they construct and maintain. So letter E, taxes, fees, and charges and other impositions upon goods carried into or out of or passing through the territorial jurisdictions of local government units in the guise of charges on for wharfage, tolls for bridges or otherwise, or other taxes, fees, or charges in any form whatsoever upon such goods or merchandise. So LGUs cannot tax goods brought into or out of or merely passing through their territory. No transit taxes in the guise of wharfage, bridge tolls, etc. Legitimate user charges for actual use of LGU facilities are allowed, but not as a tax on goods themselves. So F, taxes, fees, or charges on agricultural and aquatic products when sold by marginal farmers or fishermen. So sales by marginal producers are shielded from local taxes or fees. Letter G, taxes on business enterprises certified by the Board of Investments as pioneer or non-pioneer for a period of 6 and 4 years respectively from the date of registration. So LGUs cannot tax POI certified enterprises for the incentive period 6 years or 4 years. 6 years for pioneer or 4 years non-pioneer from registration. After the period, regular local taxes may apply. Letter H, excise taxes on articles enumerated under the National Internal Revenue Code as amended and taxes, fees, or charges on petroleum products. So LGUs cannot impose excises, for example, on alcohol, tobacco, fuel, and cannot levy and tax fee charge on petroleum products themselves. A business tax on the enterprise, for example, dealer, manufacturer, may be valid if it does not tax the petroleum product as such and is otherwise authorized by Section 143. Letter I, percentage or value added tax on sales, barters, or exchanges of goods or services except as otherwise provided herein. LGUs cannot impose VAT or percentage taxes on sales, barters, exchanges. These are national. LGUs may instead levy local business taxes on gross sales or receipts where the code authorizes. Letter J, taxes on the gross receipts of transportation contractors and persons engaged in the transportation of passengers or freight by hire and common carriers by air, land, or water, except as provided in this code. So J means that local government units cannot tax gross receipts of common carriers and transport contractors, except where the local itself authorizes. Provincial or city franchise tax under Section 137 on businesses enjoying a franchise which is measured by gross receipts. So now we proceed to K, taxes on premiums paid by way of reinsurance or retrocession. So reinsurance or retrocession premiums are excluded from local taxation. Local business taxes on insurance companies under Section 143 apply to direct premiums, not reinsurance or retrocession. Letter A, L, motor vehicle, other taxes, fees, or charges for the registration of motor vehicles and for the issuance of all kinds of licenses or permits for the driving thereof except tricycles. So these are under LTO national. LGUs may license and regulate tricycles, including permits, franchise for tricycle operation. So letter M, taxes, fees, or charges on Philippine products actually exported, except as otherwise provided herein. Exports are protected from local imposts to avoid burdening outbound goods, save for any specific code stated exception. And we, we still have N and O. Oh, here is the N and O. I think this was mixed up. So letter N, taxes, fees, or charges on countryside, barangay business enterprises, and cooperatives duly registered under our Republic Act number 6810 and Republic Act number 6938, otherwise known as the Cooperative Code of Holdings, respectively. So LGUs cannot tax these entities as protected by RA 6810 and the Cooperative Code, now updated by later statutes. The operative cooperative exemptions remain governed by current cooperative law. So letter O, taxes, fees, or charges of any kind on the national government, its agencies and instrumentalities, and local government units. So The national government and LGUs are immune from local taxation unless a specific law provides otherwise. Whether the GOCC is covered depends on its legal character and any express statutory waiver or exemption. So now we proceed to section 192. Oh, hold on for a second. We go to section 186. So this was next up. Now go to section 186, power to levy other taxes, fees, or charges. So local government units may exercise the power to levy taxes, fees, or charges on any base or subject not otherwise specifically enumerated herein or taxed under the provisions of the National Internal Revenue Code as amended or other applicable laws, provided that the taxes, fees, or charges shall not be unjust, excessive, oppressive, confiscatory, or contrary to declared national policy. Provided further that the ordinance levying such taxes, fees, or charges shall not be enacted without any prior public hearing conducted for the purpose. So Section 186 speaks or tells us that LGUs may tax any base or activity not already specifically listed in the local government code or tax under the National Internal NIRC or other laws. This is a gap-filling power, not a license to duplicate national taxes. Substantive limits: any such levy must not be unjust, excessive, oppressive, confiscatory, or contrary to declared national policy. These are grounds to invalidate an ordinance. Procedural limit: prior public hearing is a mandatory condition to enact a tax, fee, or charge. Lack of a genuine hearing is a fatal defect. So now we proceed to section 192, authority to grant tax exemption privileges. The local government units may, through ordinances duly approved, grant tax exemptions, incentives, or reliefs under such terms and conditions as they may deem necessary. Who and how? An LGU may by ordinance grant tax exemptions, incentives, or reliefs and set conditions, coverage, duration, qualifications. Limits: their limits is exemptions can only cover levies the LGU itself imposes. They cannot waive national taxes and must still respect the LG local government codes principles, uniformity, equity, public purpose, and the Section 133 common limitations. For now, we'll proceed to Section 193, withdrawal of tax exemption privileges. Unless otherwise provided in this code, tax exemptions or incentives granted to or presented enjoyed by all persons, whether natural or juridical, including government-owned or controlled corporations, except local water districts, cooperatives duly registered under RA 96938, non-stock non-profit hospitals, and educational institutions are hereby withdrawn upon the effectivity of this code. So the general rule upon the effectivity of the local government code, all tax exemptions or incentives previously granted to any person or entity, including GOCCs, are withdrawn, except for local water districts, duly registered cooperatives, and non-stock nonprofit hospitals and educational institutions. So the effect charter or contract-based local tax exemptions disappeared by operation of law unless covered by the listed exceptions or granted under a new law, valid ordinance. Courts have consistently applied this withdrawal to the local tax claims against GOCCs and similar entities, subject to the specific statutory exceptions and to separate constitutional statutory real property tax rules. So now we proceed to section 234, exemptions from real property tax. So the following are exempted from payment of real property tax. So letter A, real property owned by the Republic of the Philippines or any of its political subdivisions except when the beneficial use thereof has been granted for consideration or otherwise to a taxable person. So real property owned by the Republic of or any LGU is exempt. Exception if its beneficial use is granted for pay or free to a taxable person. For example, lease to private firm. That property or the used portion may become taxable, whether it be charitable institutions, churches, parsonages, or convents for tenant. There are two mosques, non-profit or religious cemeteries, all lands, buildings, and improvements actually directly and exclusively used for religious, charitable, or educational purposes. So, except only when the land building improvement is actually directly and exclusively used for the stated purpose. Any area used for commercial or unrelated activity is taxable. Mixed use areas are taxable pro rata. Um, Letter C, we now go to letter C. All machinery and equipment that are actually directly and exclusively used by local water districts and government-owned or controlled corporations engaged in the supply and distribution of water and or generation and transmission of electric power. So C says that water and power machinery equipment exempt are machinery. They are exempt machinery and equipment, not land or buildings, actually directly and exclusively used by local water districts and GOCCs engaged in water supply distribution and or generation transmission of electricity. Thirdly, all real property owned by duly registered cooperatives as provided under RA number 6938 tells us that this tells us that cooperatives, all real property owned by duly registered cooperatives is exempt. Ownership by a registered cooperative is the statutory basis. Letter E, machinery and equipment used for pollution control and environment protection. Exempt if the machinery or equipment is used for pollution control or environmental protection and the use is actual, direct, and exclusive. So, except as provided herein, an exemption from payment of real property tax previously granted to or presently enjoyed by all persons, whether national or judicial, including all government-owned or controlled corporations, are hereby withdrawn from the activity of this code. So, the withdrawal clause simply says that upon effectivity of the local government code in January 1, 1992, all other RPT exemptions, real property tax exemptions previously granted to any person or GOCC are withdrawn, except those expressly retained in Section 234 or otherwise provided in the code or constitution. So that's it. My voice is very low because I'm in a co-working space at Nest. So forgive me for my voice, guys. And that's all for today. Thank you.
Good morning, everyone. So I will be reporting revenue measures and collection. So here. So prior to the enactment and effectivity of a local tax ordinance, the following stages are observed. So first is the passage, second is approval, and third is effectivity. So before a tax ordinance is enacted, it must be deliberated by the Sanggunian, and importantly, a public hearing is required. This ensures community involvement and transparency. So once deliberated, the ordinance must be approved and signed by the local chief executive. So if vetoed, it can still proceed with a two-third vote by the Sanggunian members. And finally, an ordinance typically takes effect 10 days after posting, unless stated otherwise. So these, however, are subject to the procedural requirements laid down by the local government code, which will be discussed in the succeeding sections. So next is the section 187, which lays down the procedure for approval of local tax ordinances and revenue measures. So first is that public hearings shall be conducted for the purpose prior to the enactment thereof, and that any question on the constitutionality or legality of tax ordinances or revenue measures may be raised on appeal within 30 days from the effectivity thereof to the Secretary of Justice, who shall render a decision within 60 days from the date of receipt of the appeal. And that such appeal shall not have the effect of suspending the effectivity of the ordinance and the accrual and payment of the tax, fee, or charge levied therein. And finally, that within 30 days after receipt of the decision or the lapse of the 60-day period without the Secretary of Justice acting upon the appeal, the aggrieved party may file appropriate proceedings with a court of competent jurisdiction. So, Section 187 establishes the procedure for enacting local tax ordinances and revenue measures. It mandates that local governments must adhere to the provisions of the Local Government Code and, crucially, must conduct public hearings before any new tax ordinance is passed, ensuring public input. So if there's a question about the law's constitutionality or legality, an appeal can be filed with the Secretary of Justice within 30 days of its effectivity. The Secretary of Justice must then render a decision within 60 days. Importantly, filing an appeal does not suspend the ordinance effectivity, meaning that tax, fee, or charge must still be paid while the appeal is pending. Finally, if the aggrieved party is unsatisfied with the Secretary of Justice decision, or if the SOJ fails to act within the 60-day period, the party may elevate the matter by filing proceedings with a competent court within 30 days. So, relevant jurisprudence, in the case of Figueres versus CA, the Supreme Court held that petitioner is right in contending that public hearings are required to be conducted prior to the enactment of an ordinance imposing real property taxes. RA number 7160 provides that an ordinance levying taxes, fees, or charges shall not be enacted without any prior public hearing conducted for the purpose. The lack of a public hearing is a negative allegation essential to petitioner's cause of action in the present case. As petitioner is the party asserting it, she has the burden of proof. Since petitioner failed to rebut the presumption of validity in favor of the subject ordinances and to discharge the burden of proving that no public hearings were conducted prior to the enactment thereof, we are constrained to uphold their constitutionality or legality. So here the law is clear that prior to the enactment of an ordinance, there must be a prior public hearing. But it's stated here that the petitioner should or has the burden of proving it. So next case is Drilon versus Lim. So Manila City Council passed ordinance number 7794. Several oil companies and a taxpayer challenged it under Section 187 on grounds of non-compliance with procedural requirements in the enactment of tax ordinances and certain provisions alleged to be contrary to law and public policy. The Secretary of Justice declared the ordinance null and void. The RTC revoked the Secretary's resolution and sustained the ordinance, but declared the Section 187 of the LGC unconstitutional, claiming it vested too much control over LGUs in the Secretary, violating constitutional local autonomy. So the issue here is whether the Section 187 of the LGC is unconstitutional because it vests the Secretary of Justice the power of control over LGUs rather than mere supervision, thus violating the constitutional policy of local autonomy. So it was held that no, Section 187 is constitutional. The Supreme Court held that what the Secretary of Justice exercises under Section 187 is supervisory, not controlling. Next case is Hagonoy Market Vendor Association versus Municipality of Hagonoy. So it was held that Section 187 of the Local Government Code requires that an appeal of a tax ordinance or revenue measure should be made to the Secretary of Justice within 30 days from effectivity of the ordinance, and even during dependency, the effectivity of the assailed ordinance shall not be suspended. In the case at bar, Municipal Ordinance 28 took effect on October 1996. Petitioner filed its appeal only in December 1997, more than a year after the effectivity of the ordinance in 1996. Clearly, the Secretary of Justice correctly dismissed it for being time-barred. So the period stated in Section 187 are mandatory. Ordinance number 28 is a revenue measure adopted by the municipality of Agonoy to fix and collect public market stall rentals. Being its lifeblood, collection of revenues by the government is of paramount importance. Hence, the law provided a time limit for an aggrieved party to assail the legality of revenue measures and tax ordinances. So next is publication and public dissemination. So Section 188, within 10 days after their approval, certified true copies of all provincial, city, and municipal tax ordinances or revenue measures shall be published in full for 3 consecutive days in a newspaper or local circulation, provided, however, that in provinces, cities, and municipalities where there are no newspapers of local circulation, the same may be posted at least 2 conspicuous and publicly accessible places. So let's say the city of Mandaue passes a new ordinance adding a garbage collection fee. So the city approves it on October 1. By October 11, they must publish the full ordinance. If there's a local newspaper, they publish it from October 5 to 7, so 3 consecutive days. If there's no local newspaper, they might post it at the city hall bulletin board and the public market. So next is the Section 189, wherein copies of all provincial, city, and municipal and barangay tax ordinances and revenue measures shall be furnished the respective local treasurers for public dissemination. So this ensures that once any local government, be it a provincial, city, municipal, or barangay, passes a tax ordinance or revenue measure, official copies of that law must be provided to the respective local treasurers. The primary purpose of this requirement is to guarantee public dissemination. The local treasurer's office, as the primary point of the contact for tax collection and information, is tasked with making these laws easily accessible to the public. So next is enforcement of void or suspended tax measures. So Section 190 provides that the enforcement of any tax ordinance or revenue measure after due notice of the disapproval or suspension thereof shall be sufficient ground for administrative disciplinary action against the local officials and employees responsible therefore. So, excuse me. So basically, this section says that local officials sorry. So Section 190 basically says local officials or employees can face disciplinary action if they try to collect or enforce a local tax law or tax ordinance after they have been formally notified that the law has been disapproved or suspended. So in short, you can't enforce a tax law that has been declared invalid. Trying to do so is a legal offense that can lead to punishment for the officials responsible. So next is tax rate adjustment. So Section 199, 191, sorry. Section 191 provides that local government units shall have the authority to adjust the tax rates as prescribed herein not oftener than once every 5 years, but in no case shall such adjustment exceed 10% of the of the rates fixed under this code. So this gives LGUs the power to periodically raise or lower the tax rates that are set by the local government code. So this authority is subject to two very important limits. So first is the frequency limit, wherein the LGU can only adjust tax rates not oftener than once every 5 years. This means that they cannot change the rate every year. There must be at least 5 years between adjustments. So another is the rate limit, wherein that adjustment can never exceed 10% of the rate originally fixed under the local government code. This ensures that LGUs do not make sudden excessive increases. So next section is the section 192, tax exemption privileges. So local government units may, through ordinances duly approved, grant tax exemptions, incentives, or reliefs under such terms and conditions as they may deem necessary. So this section grants LGUs the power to create tax exemptions, incentives, or relief such as temporary reduction or delay in payments. So simply put, local governments can pass an ordinance to give a specific business or sector a break on local taxes, provided they set clear conditions for that break. So they can use this power to attract investment or encourage certain activities like offering a 5-year tax holiday to a new factory. So next is tax withdrawal, tax exemption privileges, or withdrawal of tax exemption privileges. So unless otherwise provided in this code, tax exemptions or incentives granted to or presently enjoyed by all persons, whether natural or juridical, including government-owned or controlled corporations, except local water districts, cooperatives duly registered under RA number 6938, non-stock and non-profit hospitals, and educational institutions are hereby withdrawn upon the effectivity of this code. So Section 193 is a landmark provision of the local government code that executed a massive cleanup of tax exemptions in the Philippines. It essentially announced that upon the law's effectivity, nearly all existing tax exemptions and incentives, both local and national, were immediately terminated or withdrawn. This included tax breaks previously enjoyed by individuals, private companies, and even most agencies and corporations controlled by the national government or the GOCCs. So the main goal was to empower local government units by expanding their tax base and ensuring that everyone, including powerful entities, contributed to the local economy. So the key exemption groups here are the local water districts, cooperatives registered under the Cooperative Code RA number 6938, non-stock and non-profit hospitals, and educational institutions. So next topic will be revenue collection. So first, Section 165 provides for the tax period and manner of payment. So unless otherwise provided in this code, the tax period of all local taxes, fees, and charges shall be the calendar year. Such taxes, fees, and charges may be paid in quarterly installments. So the standard tax period for all local taxes, fees, and charges is the calendar year, which is from January 1 to December 31. So next is the accrual of tax. So Section 166 provides that unless otherwise provided in this code, all local taxes, fees, and charges shall accrue on the first day of January of each year. However, new taxes, fees, or charges in the rates thereof shall accrue on the first day of the quarter next following the effectivity of the ordinance imposing such new levies or rates. So the accrual defines when the tax liability begins. So while existing taxes are automatically due on January 1st, the provision protects from sudden rate changes. So any ordinance introducing a new tax or altering an existing rate will only take effect at the start of the next quarter. So next is the time of payment. So Section 167 provides that unless otherwise provided in this code, all local taxes, fees, and charges shall be paid within the first 20 days of January or of each subsequent quarter as the case may be. The sanggunian concerned may, for a justifiable reason or cause, extend the time for payment of such taxes, fees, or charges without surcharges or penalties, but only for a period not exceeding 6 months. So, for example, let's say a business owner in a city needs to pay a local business tax. So normally the tax is due on or before January 20. But if the city was affected by a natural disaster, the city council or the sanggunian might allow businesses more time to pay. They can extend the deadline to as late as July 20. That's 6 months max without penalties. So next is Section 168 and 169. So Section 168 provides for the surcharges and penalties on unpaid taxes, fees, or charges. It provides that the sanggunian may impose a surcharge not exceeding 25% of the amount of taxes, fees, or charges not paid on time, and an interest at the rate not exceeding 2% per month of the unpaid taxes, fees, or charges, including surcharges, until such amount is fully paid, but in no case shall the total 36 months. So, for example, if you don't pay your local taxes on time, the local government or the sanggunian can add a surcharge or penalty of up to 25% of the unpaid amount, charge interest of up to 2% per month of the unpaid amount, including the surcharge until it's fully paid. But the total interest cannot go beyond 36 months or 3 years, no matter how long you delay. Section 169 provides for the interest on other unpaid revenues, where the amount of any other revenue due a local government unit, except voluntary contributions or donations, is not paid on the date fixed in the ordinance or in the contract, expressed or implied, or upon the occurrence of the event which has given rise to its collection, there shall be collected as part of the amount an interest thereon at the rate not exceeding 2% per month from the date it is due until it is paid, but in no case shall the total interest on the unpaid amount or portion thereof exceed 36 months. So, for example, if someone owes money to the local government and they don't pay on time, the local government can charge interest of up to 2% per month starting from the due date. This interest continues until the amount is fully paid. But the total interest cannot go beyond 36 months, even if the payment is delayed longer. So this rule does not apply to voluntary contributions or donations. So next is Section 170, which provides for the collection of local revenues by treasurer. So all local taxes, fees, and charges shall be collected by the provincial, city, municipal, or barangay treasurer or their duly authorized deputies. The provincial, city, or municipal treasurer may designate the barangay treasurer as his deputy to collect local taxes, fees, or charges. In case a bond is required for the purpose, the provincial, city, or municipal government shall pay premiums thereon in addition to the premiums of bond that may be required under this code. So, for example, local taxes, fees, and charges must be collected by the treasurer of the province, city, municipality, or barangay or by their authorized deputy. So a barangay treasurer can be assigned by a higher level treasurer, like the city or municipal treasurer, to help collect these payments. So if the barangay treasurer needs to have a ban, the provincial, city, or municipal government will pay for the bond premiums. So next is section 171, the examination of books of accounts. So who is authorized to examine? So the local treasurer from the provincial, city, municipal, or barangay, or his duly authorized deputies, for the purpose of ascertaining, assessing, and collecting the correct amount of the tax, fee, or charge, which must be conducted during regular business hours and only once for every tax period. So examination must be certified by the official, and the certificate must be made of record in the taxpayer's books. The written authority must specifically state the taxpayer's name, address, business date, place, and procedure of examination. And as to access of records, the records of the BIR Revenue District Office shall be made available to the local treasurer. So for example, let's say a business in a city is suspected of underpaying its local business taxes. So the city treasurer or their authorized deputy can visit the business during working hours to check if financial records, financial records rather. So they can do this only once for the year if that's the tax period. So if it's a deputy, their letter of authority must say exactly which business they are checking, where and when and how. They may also use data from the BIR to verify the business income. So moving on to the civil remedies. So civil remedies refers to the remedy of the LGUs, while the taxpayers' remedies refers to the remedies of the taxpayers. So section 174 provides that the civil remedies for the collection of local taxes, fees, or charges, and related surcharges and interest resulting from delinquency shall be first is administrative action through distraint of goods, chattels, or effects and other personal property of whatever character, including stocks and other securities, debts, credits, bank accounts, and interest in underwrites the personal property, and by levy upon a real property and interest in or rights to real property. And second is judicial action. So either of these remedies or all may be pursued concurrently or simultaneously at the discretion of the local government unit concerned. So, for example, if a business doesn't pay its local business tax, the city government can freeze its bank account or restrain, seize and sell its equipment, or go to court to force payment, which is money on judicial action, or to do both at the same time. So additionally, the remedies by distraint and levy may be repeated if necessary until the full amount due, including all expenses, is collected. Excuse me. So next is distraint of personal property. So, sorry. So next is the section 175, which is distraint of personal property. So here are the steps. So seizure, accounting of distrained goods, publication, release of distrained property upon payment prior to sale, procedure of sale, and disposition of proceeds. So if in seizure, if someone doesn't pay their local taxes, the local treasurer or deputy can seize personal property equal in value to what is owed. A written notice must be given. An official certificate showing the unpaid tax amount will be used as proof and authority for the seizure. Some types of property may be exempt from seizure under other laws. So next is Section 185, mentioning the personal property exempt from restraint or levy. So Section 185 provides that the following property shall be exempt from restraint and levy, attachment, or execution thereof for delinquency in the payment of any local tax, fee, or charge, including the related surcharge and interest. A. Tools and implements necessarily used by the delinquent taxpayer in his trade or employment. B. One horse, cow, carabao, or other beast of burden, such as the delinquent taxpayer may select, and necessarily used by him in his ordinary occupation. C. His necessary clothing and that of all his family. D. Household furniture and utensils necessary for housekeeping and used for that purpose by the delinquent taxpayer, such as he may select of a value not exceeding 10,000 pesos. E. Provisions including crops actually provided for individual or family use sufficient for 4 months. And F. The professional libraries of doctors, engineers, lawyers, and judges. G. One fishing boat and net not exceeding the total value of 10,000 pesos, by the lawful use of which a fisherman earns his livelihood and age, any material or article forming part of a house or improvement of any real property. So, for example, a farmer owes local taxes but has only one carabao, some basic furniture, and rice stored for family meals. So these cannot be taken by the government to pay tax. So moving on to the taxpayers' remedies. So previously we discussed the civil remedies. And now we move on to the taxpayers' remedies. So Section 194 provides for the periods of assessment and collection. So in period of assessment, local taxes, fees, or charges shall be assessed within 5 years from the date they become due. No action for the collection of such shall be instituted after the expiration of such period, except in case of fraud or intent to evade payment of taxes, fees, or charges. The same may be assessed within 10 years. So, period of collection is 5 years from the date of assessment by the administrative or judicial action, and suspension of periods during which the treasurer is legally prevented from making the assessment of collection. The taxpayer requests for a reinvestigation and executes a waiver in writing before expiration of the period within which to assess or collect. And third, the taxpayer is out of the country or otherwise cannot be located. So next is protest of assessment, Section 195. So what to protest? So after the receipt of the notice of assessment from the treasurer, the taxpayer may file a written protest within 60 days to contest the assessment. Otherwise, the same will be final and executory. So the local treasurer shall decide the protest within 60 days from its filing. So if the protest is meritorious, the treasurer shall issue notice canceling wholly or partially the assessment. And if not meritorious, the treasurer shall deny the protest with notice to the taxpayer. The protest may likewise be considered and denied if not acted upon within the 60-day period. And lastly, the taxpayer shall have 30 days from the receipt of denial or from the lapse of the 60-day period to appeal with a court of competent jurisdiction. Otherwise, the assessment becomes conclusive and unappealable. So next is the claim for refund or of tax credit. So Section 196 provides that no case or proceeding shall be maintained in any court for the recovery of any tax, fee, or charge erroneously or illegally collected until a written claim for refund or credit has been filed with the local treasurer. No case or proceeding shall be entertained in any court after the expiration of 2 years from the date of the payment of such tax, fee, or charge, or from the date the taxpayer is entitled to a refund or credit. So for example, if a person or business pays a local tax fee or charge by mistake or illegally, they must file a written request with the local treasurer to ask for a refund or tax credit. You cannot go to court right away. You must file the claim with the treasurer first. Also, you only have 2 years to file the claim. This 2-year period starts either from the date the tax was paid or the date you became entitled to a refund or credit. If you do not file within 2 years, you lose the right to claim the refund or go to court. So, example, if you accidentally paid a tax on October 1, 2023, you have until October 1, 2025 to file a refund claim. If you miss that deadline, you can no longer get your money back. So, that ends my report for revenue measures and collection, and thank you.